You're in for a real treat tonight because we have Amanda Buzo, who is the Executive Director of Community Fund Ohio here in Akron. She is an attorney who graduated from The Ohio State University and the University of Akron School of Law. Prior to joining the Community Fund Management, Amanda focused her practice on special needs law, probate, estate planning, guardianship, and elder law. She is now responsible for over 5,000 first-party and third-party special needs trusts and oversees community fund grant programs. I'd like to introduce Ms. Amanda Buzo. If you have any questions during or after the presentation, please put them in the chat and we'll address them at the end. So Amanda, take it away.
Wonderful. Thank you so much, Wendy. And let me say, this organization is very fortunate to have Wendy. I think I am better prepared for this webinar than I have ever in any other webinar that I've been doing these past couple of years. So kudos to her for her very efficient and helpful tips to make sure that I'm ready tonight. If I'm not ready, it's all because of me and not because of her in any way. The other congratulations is thank you for pronouncing my last name correctly. I get a lot of variations, but you did so accurately, so thank you so much. So I'm going to share my screen here. And our presentation tonight is titled Special Needs Trust, Stable Accounts and Grants, oh my. So if you are a Wizard of Oz fan, hopefully that appeals to you. And we're going to talk about a variety of items. I definitely encourage you to ask questions. We'll be happy to go over them at the end. Wendy also very kindly provided me with a couple of questions in advance. And so I'll be sure to get to those during the presentation. So let's start with why might you be here tonight? It is possible that you are planning for a loved one with a disability, specifically someone who might be on the autism spectrum. And as a result, you might be already receiving government benefits, or you might be planning for government benefit eligibility in the future. Now, many government benefits are acronyms, and people can easily get them confused. And if you get them confused, you are not alone in any way. I speak with people every day who use these terms interchangeably, and sometimes the details are really important. So the more you can familiarize yourself with the definitions and the acronyms and what they mean, I think the more comfortable you will feel in working as your loved one gets older. So SSI, or Supplemental Security Income, is a very popular means-tested government benefit. Medicaid can mean a variety of things. It can be age, blind, and disabled Medicaid. It can be Magi Medicaid. If you happen to have someone in your life who is maybe a little bit older, they might be in a long-term care facility. There's nursing home Medicaid. There's a variety of things. And if you lived in a different state, they may call their Medicaid a different name than what Ohio does. So what I'm using tonight are terms that are used in Ohio, but if you're from another state, you might actually have different terms for the same programs. There's waiver. Waiver is offered in a variety of ways. A lot of the waivers that you might be familiar with are offered through the DD board. So that would be the level 1 waiver, the individual options or IO waiver, or the self waiver, which is, in the whole scheme of things, a little bit newer. There may be subsidized housing or food assistance. And not only are we planning for the benefits that someone receives today, but we're also planning for what may happen in the future. I like this chart because I think sometimes it's difficult to remember what the different benefits provide and whether they're means tested or not. So means tested means in order to be eligible, you have to meet certain financial criteria. That might be your income, that might be the money in the bank, which we refer to as a resource or an asset, or there may be no financial test at all. So Medicaid and waiver are a type of health insurance. And in order to be eligible, you must meet certain financial criteria. On the other hand, Medicare is also a health insurance, but it's not means tested. So you could win the lottery or have $1 million in the bank and still be eligible for Medicare. With respect to cash benefits, so that would be typically a monthly check. SSI, as I mentioned before, that you can only be eligible for if you meet certain income and resource tests. On the other hand, Social Security Disability Insurance, or SSD or SSDI, they all mean the same thing. Those are not means tested. So while you must be a person with a disability and you must not be able to work and earn over a certain dollar amount, you again could have $1 million in the bank and still be eligible for Social Security Disability. So a lot of what I'm talking about tonight is to retain eligibility for Medicaid or waiver or SSI, or to plan in the event that someone needs it in the future. If you're sitting at home tonight watching this and you have a 4-year-old, they may not be receiving some of these programs, but when they turn 18, you might be applying for them. Conversely, if you are planning for a loved one who is currently working, then you might be looking at the Social Security Disability or Medicare. So what are some of the special needs planning options? What are the things you would Google if you were trying to figure out, what do I need to do for my loved one? You may have heard of special needs trusts. That's a very general term. It doesn't actually refer to a specific type of trust. What it typically means is the beneficiary is a person with a disability, and it means that you might be, that person might need means tested government benefits. So that person might be on Medicaid, they might be on SSI. You do not need to be receiving benefits in order to be a beneficiary of a special needs trust. It's not a requirement. But you do have to be a person with a disability. Disability, we typically follow the Social Security Administration's definition, which means a physical or mental impairment that lasts 12 months or longer, or will unfortunately result in death. So if a person meets that criteria, they are most likely considered disabled by the Social Security Administration. So there are two types of special needs trusts. There is the third-party trust, or there is a Medicaid payback trust. What's the difference? The difference is who's putting the money into it. We're going to talk about that in more detail. There's also something called an ABLE account. If you're an Ohio State fan, you may have seen Coach Tressel and Coach Urban Meyer talking about stable account. That is the Ohio version of ABLE account. It's not a trust, but it is an investment option, and it is exempt when someone is applying for Medicaid or SSI in most situations. We're going to talk a little bit about that tonight as well. And then the last item, which I include because a lot of people I talk to include, but it doesn't actually belong on this slide, is guardianship. Now, if a person with a disability is under guardianship and they receive money, and that money is held in the guardianship, it's actually still counted for Medicaid and SSI eligibility. So if you are someone out there who has a loved one under guardianship, and there is a guardianship of a state, and there's money that's under court supervision, please note that that guardianship is not exempt. It is still counted unless it's in an ABLE account, or unless it is in a special needs trust. So when we're trying to plan for the future, we recognize that we're unsure of future government programs. I mean, when I started practicing law, you could not pay for certain things out of a trust, like clothing. Now you can definitely purchase clothing out of a trust. So that changed even just in the past 15 years. There was no such thing as a self waiver that came along a couple years after I had been practicing. And we're also not clear on our loved ones' future needs as they mature. If you're working with someone who is, 20 years old or younger, they still have quite a bit of maturation, and you don't know what their future holds. Even if they're in their 20s, 30s, 40s, you don't necessarily know what their future holds. So we're trying to plan as much as we can without knowing what's going to be available and what our loved ones' needs are going to be. We do understand that generally giving funds directly to the person with a disability can disqualify them from means-tested government benefits. So if you are parents and you're planning for a child, whether they are an adult or a minor, and you also have parents, if your parents leave money to their grandchild, that could cause them to be ineligible for means-tested government benefits. Similarly, if you leave money directly to the individual with the disability, you could disqualify them from means-tested benefits. So we know that to pretty much be true. If you give money directly to a person with a disability, you might force them to have to spend down the money, sometimes on unnecessary items. So if we have someone who receives SSI or Medicaid, or maybe lives in a group home, and that individual needs to stay eligible for their government benefits, but they're accumulating a little bit of money. Sometimes they end up going on clothing shopping sprees or buying a lazy boy recliner that they don't really need because they're just trying to spend down so they stay eligible for those government benefits. Someone that I work with told me a story of a situation where they were speaking with a group home, and they looked out in the backyard of the group home, and there were multiple gazebos in the backyard of the group home. And she asked, "Why do you have so many gazebos? Does someone here really enjoy gazebos?" And they said, "Oh, well, every time Tommy, one of the residents, every time he's at risk of losing his waiver because he has excess money in the bank, we go and buy a gazebo." So their backyard was littered with gazebos. Did that benefit him in any way? Maybe the first gazebo, but I don't think the second or the third gazebo benefited him. So it's really important to recognize that spending down can be helpful, but when you're buying a second gazebo, maybe we've crossed the line. When you leave funds to a person with a disability, it might require guardianship or probate court involvement if that individual is not competent to manage those assets. And there is a risk of losing the funds if the loved one is easily influenced. I have a family member with developmental and cognitive disabilities, and if you ask him to open up his wallet and give you the money, he'll do it. So we have to be very careful to make sure that he doesn't have more than $5 or $10 on him. Can you imagine if he had access to hundreds or maybe even $1,000? It would easily be gone. So now that I've told you the depressing story of look at all these things that can happen, what can we do about it? Well, the good news is that there are options. The bad news is that there are options. And so it's not a one size fits all. I really applaud you for being here tonight. I know there's probably a lot more things that you would rather do, but getting this information I think is really helpful because you can decide what works best for you, your loved one, your family, whoever you're planning for. So what can you do? There's the stable account that I mentioned before, and I have a couple of slides discussing the stable account and giving you more details. You could disinherit the individual. That's what my family did. We had older family members that wanted to leave money for the family member with the disability. So they left it to some of us and said, you know, wink, wink, nudge, nudge. This is for our loved one. We want you to use it for them. That is very dangerous to give that individual share to someone else and hope that they don't predecease or misuse the funds. I'll use me as an example. What if my family members gave it to me and said, this is for your nephew, for example, and my spouse started whispering in my ear saying, well, your nephew doesn't really need to use it. His needs are taken care of. Why don't we use it for that vacation or to make modifications to our house, or, you know, those things that we always wanted to do. Let's pay for our own children's college. Or what if, God forbid, I got into a car accident and I was sued? Perhaps I was at fault. And the money that was earmarked for my nephew is now being potentially used to pay for a creditor, like if you were in an automobile accident and they sued you personally. You could gift assets directly through like a will or put the person on your bank account, but realize that it's likely they're going to lose eligibility for government benefits. You could also establish a special needs trust. So let's talk about that. Third-party trust. What does that mean? It just means that anyone other than the person with the disability is putting their money into the trust. It could be a parent, a grandparent, a sibling, a neighbor. I'm aware of some neighbors that have really wanted to create special needs trusts for the neighbor that they grew up with. It can be anyone but the beneficiary. If it's drafted correctly, meaning the lawyer that you hire has written it correctly, it will not jeopardize government benefits. It's not counted as a resource and it's not counted as income, even if the beneficiary receives Medicaid, waiver, SSI, food assistance, Section 8 housing. It doesn't have to be counted and they can still be eligible for those programs. You may have heard about Medicaid Payback, or if you have maybe an elderly individual that you're planning for, you may have heard about the 5-year look back. None of that applies here. It does require a trustee who cannot be the beneficiary. So even if your loved one is perfectly able to manage money, they can't be their own trustee. So you always have to have someone else. If it's revocable, meaning it can be changed, the income earned by the trust is included on the income tax return of the person who set it up. So if you're mom and you set up a revocable third-party trust for your daughter and you put money into the trust while you're living, any income that that trust earns is going to be reported on your own 1040. On the other hand, if it's irrevocable, meaning it cannot be changed, the tax rules are different, and the trust income is typically reported on the trust income tax return, which is called a 1041 instead of our individual easy 1040 or 1040 regular. There is no minimum or maximum needed to fund a trust, and every family has a different funding goal. So you can fund it immediately if you are in the position to do so. You could fund it in the future, meaning maybe after like the parents or grandparents pass away, maybe that's when the trust gets funded. It can receive life insurance or other assets. It just can't be funded with the beneficiary's own assets. Now, sometimes people say, well, I don't have someone in my life who could manage this trust. And way back in 1993, that was the case for many families who were using DD board services. And so Community Fund offers a third-party pooled trust called a master trust. Community Fund is not associated with the DD board, but when we first started, it was because of actually Cuyahoga County Board of DD. And for a little while, we were funded by many of the DD boards, including Summit and Portage and many others that your counties that you probably recognize. But now we are completely an independent, standalone nonprofit. So we ourselves are a charity. We're a 501c3, and we manage special needs trusts for beneficiaries with a disability. So we offer a type of third-party trust, but you can also go to an attorney and have them create one just for you. So how do you fund this? We talked about lifetime gifts. You can name the trust as a beneficiary in your will, or maybe you have a second trust. You can name the trust as the beneficiary designation, like payable on death on your bank account. And you can share information with your loved ones so that they can contribute too. So if you are divorced parents, but you can agree to an estate plan where you both use the same trust, maybe you'd make it irrevocable so neither one of you could change it. But divorced parents can use a singular trust and save on attorney fees and other expenses. You can share the information with grandparents and aunts and uncles and other people and contribute to the trust. But what if we're concerned about someone being over resources themselves? Like the person with the disability has over resources. And a common example of this that I saw when I was in private practice was I would have parents coming to me saying, my child is 18. They accumulated their birthday and holiday and graduation money if they graduated at 18 and did not extend to 22. And they accumulated all of that. And oh my gosh, they've got $5,000 in their savings account. You know, isn't that a problem we'd all like to have, where we have extra money that we don't know what to do with? But for someone who needs to apply for waiver or Medicaid or SSI, that $5,000 is going to cause them to be over resources. The test actually is $2,000 for SSI. You can't have more than $2,000 in countable resources, which would include like your savings account. Other ways that this could happen would be if there was maybe an improperly drafted trust, or maybe it's just an old trust. Maybe, you know, estate planning was done back in the 80s and never updated, and it's not drafted properly for the situation today. Maybe there's a direct gift. Maybe someone intended something really positive and gave a large check, and now it's causing the person to be ineligible. An inheritance, accrual of wages, accrual of Social Security income, too much money in the resident account, a personal injury settlement, back payment from Social Security. All these things can cause someone to be over resources. It actually happens way more than I would have expected. So what is the option? There's what's known as a first party special needs trust. Now this one can only be established by a parent, a grandparent, a guardian, a court, or a competent beneficiary. So the third party trust can be established by anyone other than the beneficiary. The first party trust can be established by an adult beneficiary who's not under guardianship, and it can also be established by a parent, grandparent, guardian, or court. But those are the only 5 people that can establish it. And not to get too much into the weeds, but there's 2 types of first party trusts. There's the Medicaid Payback Trust and the pooled Medicaid Payback. Community Fund, which is us, we offer a pooled Medicaid Payback Trust, which just means for investment purposes, all the assets are pooled together. We are one of the largest in the country in terms of assets under management and in terms of number of beneficiaries. So it's kind of neat thinking that an organization, a little nonprofit like us in a suburb in between Cleveland and Akron, is able to accomplish so much. Now, here's the thing about Medicaid Payback Trusts, the name. At the death of the beneficiary, so the person with the disability, Medicaid is entitled to be repaid. So if the person was on waiver or was on community Medicaid, the state of Ohio is entitled to be repaid for those Medicaid services. So here's a really important point. If you are, for example, a parent planning for a child, and you have parents and you have concerns about them maybe not doing planning, and they're leaving money to your child thinking they're doing something good, the thing to stress to them is they really need to look at a third-party trust, because with a third-party trust, they have way more control. There's no Medicaid payback at their grandchild's passing. There's a little bit more flexibility. If they leave their grandchild with a direct inheritance, chances are that grandchild is going to have to do a Medicaid payback or a pooled Medicaid payback. And there are restrictions, there are a little bit more restrictions on the pooled Medicaid payback. So if the grandparents or the parents do the planning during their lifetime, or the sibling do their planning during the lifetime, they can avoid having to create the Medicaid Payback Trust. But the good news is that if there is a reason, if the Medicaid Payback Trust is needed, it's available. We have a good option here. And Community Fund, as I mentioned, offers the pooled Medicaid payback. It has to be administered by a nonprofit, which is where we come in. And the money can be left to the nonprofit. And for those people who leave the money to Community Fund, we use it for our grant program, which I'm going to talk about at the very end, assuming that there's time. So I wanted to include some of these slides so that you can look at them at your convenience. If you have difficulty falling asleep tonight, you can pull these out and I'm sure they'll lull you right to sleep. But I don't want to get too much into the weeds. I just wanted to make sure that you had this information. So if you go and speak with an attorney or a CPA or another advisor, that you feel like you have good information that you can refer to. So distributions from a trust. So whether we're talking about that third-party trust or the first-party Medicaid Payback Trust, what can you use the trust for? Well, when planning for a beneficiary with a disability, the trust language is normally really broad. You would think it would be the opposite, right? Like it would get really nitty gritty, like you can pay for, gym membership on the third Tuesday of every month, but that's all you can do. Actually, no, it's the opposite. It's really, really broad because we want to be able to evolve as government benefit rules evolve. We don't want to require specific distributions. If the trust says you have to give the beneficiary $500 a month, chances are they're going to lose their eligibility for Medicaid and waiver and SSI. So we don't include those kind of things. We also don't include those ascertainable standards. So we don't say the beneficiary's health has to be paid for, or their education or maintenance or support. So if you do have a trusted home and you feel like it, you can look through it and see if there's language like this. And if there's a person with a disability that's meant to benefit from that trust, you might want to think about revising that language, because that language will likely cause the trust to be counted if the person applies for Medicaid or SSI or other means tested benefits. So it's easier to actually say what the trust cannot pay for. And the first question we ask is, what benefits does the beneficiary receive? Because if the beneficiary, who's the person with the disability, if they receive Medicaid or SSI, then we can't pay for certain things. And it's not because we're mean, and it's not because we enjoy saying no.
It's because the government benefit rules say that if someone like a trust pays for this, we're going to ding you. So our goal is to keep people eligible for their benefits. So we don't pay for food, although that could be changing. Rumor is that might be changing, but for right now, we don't pay for food. We can't pay for shelter expenses. We can't pay for gift cards because sometimes those gift cards can be converted to cash or can be used to buy food. We don't make gifts to others because it's only for that beneficiary. The trust is only for their benefit. And if there's other prohibited items. So if you think about working with a bank trustee or a family member trustee, or you're thinking about working with community fund, you might want to ask, what are those prohibited items? Maybe they don't approve, I don't know, marijuana. Maybe they don't approve ammunition for guns. Those types of things you kind of need to talk about. And if the beneficiary is receiving Medicaid or SSI, or is in subsidized housing, the trustee cannot just give the beneficiary cash. The trust cannot be an ATM machine. But what can it pay for? So many things. Internet, cell phone, landline, if you still have it, security system for their residents, medical expenses, including insurance, elective procedures, dental vision, things that Medicaid doesn't pay for, or things that Medicaid doesn't pay for enough. We a lot of times make payments for wheelchairs that Medicaid won't approve, or special fittings that Medicaid won't approve. We oftentimes pay for those types of things. Reasonable vacations. And of course, everyone has a different definition of reasonable vacation, right? Some people say, $700 and nothing more. And other people say, let's spend $12,000. So we all have different definitions of what's reasonable, but reasonable vacations for the beneficiary and possibly an aid if an aid is necessary for travel. Possibly food. Remember, I said, right now there's a prohibition against food, but if it's on vacation, it's actually allowed. Lodging, transportation, attractions. This is sometimes why people work with an organization like Community Fund, because knowing the nuances of all these rules can be quite daunting. And people will ask, well, isn't there like a central location where these rules are located? Yes and no. You'd have to comb through the Social Security Operations Manual, which is called POMS. P is in program, O, M is in manual, S is in Sam. I'm sorry, I don't actually know what the acronym is, but it's some, I think it's Program Operation Manual Support, something like that. But if you Google Social Security POMS, you will see it. It is quite involved. The Medicaid rules are in the Administrative Code and in the Ohio Revised Code. And also a lot of it just comes from experience and being able to read through the lines or read between the lines and be able to make certain arguments on things. So that's one of the benefits of working with an organization like Community Fund. So what can the trust pay for again? Renter's insurance, homeowner's insurance if there's no mortgage, hobbies like video games and gym memberships, transportation, including the purchase of a vehicle, Uber, bus pass, pet care, whether they're a companion animal or whether they are a service animal, travel for the guardian or caregiver to visit the beneficiary. So if the beneficiary lives in Ohio, but their sibling lives in Texas, and their adult sibling needs to come to Ohio to check on their brother or sister to make sure that they're, eating okay, and that they're, going to their vocational program, and that the social worker is visiting them, whatever it might be. The trust can actually pay for the transportation of the guardian or caregiver to come and visit the beneficiary, and much, much more. Okay, trusts and ABLE accounts. I will say, I think ABLE has a really good website. I think they can explain their program, better than I can. So their website is right here, stableaccount.com. if you have any questions about the stable account, go on there and look through. They've got frequently asked questions. I was just on there a couple of weeks ago, and it strikes me as very helpful. And most of the questions that I think people ask can be answered on that website. But let me compare a little bit between stable and a trust. People will call me sometimes and say, well, should I have a stable account or should I have a trust? And I'm like, well, I work for community fund, so I'm going to say trust every time, right? Actually, no. And I'm not involved in planning anymore. So that's really not an appropriate question to ask me. It's more your advisor. However, because it does come up, it's something that I like to stay on top of. A stable account is not a trust, and a trust obviously is. But both are exempt if they are administered properly. A stable account is funded with anyone's assets. The person with the disability can have direct access. They can actually have a debit card. Whereas if it's a trust and you give the beneficiary direct access, the trust will be counted as a resource and the whole thing will blow up. So very different rules. A stable account can be used for qualified disability expenses, which were actually defined by the Internal Revenue Service, not Medicaid, not Social Security, but the Internal Revenue Service. So ABLE accounts are actually found in the Internal Revenue Code, right by 529 plans. Trusts are used to supplement what the beneficiary receives through Medicaid and SSI and other programs. So we have to be very careful to stay eligible for those programs. For stable, there is a limit on annual contributions. Right now it's 16,000. It's actually tied to the gift tax exclusion, annual exclusion. So that's 16,000 right now. So the contributions are 16,000. There's also lifetime contribution limits to stable. Anything over 100,000 is going to be treated as a resource by SSI. But if you think about it, if you can only contribute up to 16,000 and a lot of people are not contributing the maximum each year, it's going to take you a little while to reach $100,000. And stable accounts definitely have the repayment to the state for Medicaid since the account was established. So they start tolling when the account was set up, not the beneficiary's birthday or not when they started getting Medicaid, but actually when the trust was set up. And so there is the repayment to the state, even if the parent's money goes into the stable account. With respect to the trust, there is no minimum or maximum contribution limits. There's no lifetime contribution. It's not a countable resource no matter how much is in it if it's drafted properly. And there is repayment to the state, but only if it's that first party trust. And it's for Medicaid expenses provided over the lifetime of the beneficiary, not just since the trust establishment. So to summarize, if you're planning for third-party assets, meaning assets never belonging to the person with the disability, you could do a third-party trust. You could do a pooled third-party trust. Community Fund calls that our master trust. You could do a stable account. If you're planning for the individual with a disability with their own assets, you have options like the Medicaid Payback Trust, the pooled Medicaid Payback Trust, or again, the stable account, because stable could work in either situation. So I'm frequently asked, how do I select an attorney? When I was, a very worldly 25-year-old, yeah, right, I didn't know anything, but I was licensed to practice law. And I felt like I was very capable of doing so. I know I did a good job for my clients, and I like to think I worked really hard, especially because I was newer. But I'm also shocked that people trusted me with advising them. It is scary. I don't trust anyone advising me now. I question everything. And I don't blame people when they question me. And it can feel kind of scary out there, knowing whether the information you're getting is accurate, is it biased, is the person staying up to date? So a lot of times I get asked, how do I evaluate whether or not the attorney I'm talking to is someone who's qualified? And here are some questions that I think you might want to ask. For example, if you're meeting with an estate planning attorney, you could ask them, how many special needs trusts have you drafted? If they tell you you're the first one, do you want to be their first one? I would ask, do you serve as trustee? Why or why not? I don't think there's a wrong answer here, but I will tell you the way I drafted my trust changed after I needed to be the trustee, because I did serve as trustee for many of my clients. I was also guardian for many people. And my experience was definitely, or I should say my attitude was definitely influenced by my experiences, and the things that I wrote changed over time because of my experience as trustee. So that's a question you might want to ask. Again, I don't think there's a wrong answer. It just might give you a little bit of insight into their practice. Do you represent people appealing denials by Medicaid or SSI or SSDI? There are many estate planning attorneys who do special needs planning who don't represent people who are denied for the government programs. That's fine. Could they refer you to someone? What if they draft a trust and your child is 15? Your child then turns 18, you go to apply for benefits and they tell you the trust is countable. What will the attorney do in that situation? Will they help you appeal? Will they revise the trust? What is that long-term commitment? How frequently do you read POMs? Social Security definitely has a role to play with special needs trust administration. If they're not familiar with POMs, their trust agreement may not be in the best shape. What organizations do you belong to? Are they committed to the special needs community, to like-minded attorneys? Are they staying up to date on changes? And then of course, the last question is, how do you stay updated on law changes? Here are 3 resources. I think there's good articles. Many of them branch into other things like podcasts and webcasts and things like that. They also have attorney directories. I believe the Special Needs Alliance and the Academy of Special Needs Planners might be a smaller directory. National Academy of Elder Law Attorneys is a larger directory. Many of the issues that impact elders when it comes to Medicaid eligibility are the same issues that can impact younger individuals. So there's many attorneys that do both. So that's why I include the National Academy of Elder Law Attorneys on there. But there are attorney directories that you can use to find someone in your area that may be helpful to guide you. And I just want to spend a couple minutes on our grant program. We offer grants. We offer grants to nonprofits that serve Ohio residents with disabilities. And then we also offer grants for Ohio residents with disabilities. And I'm going to focus on the individuals. If you work or are involved in an Ohio nonprofit, definitely give our website a look and see if maybe they want to apply for a nonprofit grant. But for our purpose tonight, I'm going to focus on individual eligibility. So in order to be an individual and apply for a grant application, or a grant, excuse me, you need to be an Ohio resident. You need to have a disability, and the request needs to be for a disability related expense. We have 3 types of individual grants. There's one if you are one of our former trust beneficiaries. So if you used all of your money during your lifetime, you could apply for a $1,500 lifetime maximum if you previously worked with us. If you have a financial hardship, which means that the applicant receives SSI, Medicaid, Healthy Start, Healthy Families, waiver, they can apply for up to $5,000. And then if the individual is an Ohio resident with a disability, but they do not receive SSI or Medicaid, then they can apply for a $1,500 grant. So what are disability-related expenses for community funds grants? Well, some common examples are home modifications like shower grab bars, or modifying hallways and doorways for wheelchairs, or just making the home more accessible. Vehicle modifications like hand controls, wheelchair ramps, tie downs. Educational expenses. We had a young man recently who wanted to go to college. He was diagnosed with autism, and there was a college that had a great program. And so we helped contribute towards the cost of his educational expenses. So I believe it involved books and tuition. Camps are very popular. Therapy not fully covered by insurance, like HIPAA therapy or music therapy, very popular. Life coaches, especially for individuals with autism, that's a very popular grant request. Communication devices, even if they're commercially available. So just because it's an iPad doesn't mean it can't be a communication device. So that is a very popular request as well. Things that we can't approve, things that are non-disability related, utility bills, rent or mortgage, contribution towards a vehicle that is not wheelchair accessible and has no other modifications, home repairs unrelated to a disability, general spending money. We do get a fair amount of applications that say, I would like $5,000. And we say, you know, that's great. We understand that you want $5,000, but we can't just cut you a check for $5,000. We have to know what you're going to use it on. And if it's not a disability related expense, we unfortunately are unable to approve it. Or anything that could cause the recipient to lose eligibility for Medicaid or SSI. So if you want to apply for yourself or on behalf of a loved one, you can download our application from our website. You can call our office and speak with Lisa and ask for a hard copy to be mailed to you if you do not have access to a printer or a computer. And then you fax or mail the grant application to our office. We review them after the end of every quarter, but we accept them at any time. So for example, the second quarter will end at the end of June in a couple weeks here. We will be reviewing them in July or August and making decisions at that time. But you can send it in at any point. We do recommend maybe towards the beginning of the year because we renew our grants, our grant dollars every year. So at the beginning of the year, we have the most amount of money. There is the risk that in fourth quarter, we could have spent all the money during the year. So it is better to apply earlier in the year, but in no way is that a requirement. And we typically do still have money in fourth quarter. So please don't be discouraged. And if you do get denied because we have exhausted all of our funds, you could still reapply. So if you have questions about grants, please give our office a call. That's our information for our grants. And this is our information for our organization in general. If you have questions about setting up with a community fund trust and you want to email us, please don't send us super personal information. Please don't email us social security numbers or dates of birth. We don't need that in order to have a conversation, and we want to protect your confidential personal information. But if you'd prefer to email instead of giving us a call, you're more than welcome to email the joinder and deposit, and our team will be happy to get back to you. So I wanted to make sure I touched on a couple of the items that were asked prior to this evening. And one of the questions was, is it easy to release trust funds for special or emergency times? And I would say that is definitely a question to ask whoever is administering the trust. I can speak on behalf of Community Fund, which is we treat everything the same. As soon as it comes into our office, we are processing it. There really isn't an opportunity to do it faster because we're already doing it in the order that it comes in. And there are, I will say there are a couple of times where we will bump something up. For example, vehicle inventory is really difficult right now. And so if someone finds a vehicle that they need our trust to pay for and we agree with it, we want to make sure that we can get that money to the seller right away, because there's a risk that they could sell it to someone else, because inventory has been affected by supply chain and COVID and all those things that we're dealing with right now. So there are situations, similarly buying a house, there's lack of inventory out there. And so if we know that it's a distribution for a house or a car or medical expenses, we will bump that up to the top of the list. But generally speaking, we approve things, or we review them and hopefully approve them as they come in, and we move pretty quickly on that. Is the trust portable in the event another guardian is needed? So guardianship and trust are actually two unique things. You don't have to have a guardian in order to have a trust, but you can have a guardianship and have a trust. So I think what this means is that maybe if the beneficiary moves out of Ohio, can the trust move? And it depends on how the trust is written. I can tell you with Community Fund, if a beneficiary moves out of Ohio, we ask them to set up a new pooled trust in the new state of residence, because we only know Ohio law and we only work with Ohio beneficiaries. What requirements does my son need to qualify for a trust other than the fact that he was diagnosed with Ssdi? That is a question to ask the trustee. For us, that is enough. We do not do an independent disability determination. We depend on the person setting up the trust and their attorney to decide if the person meets our criteria. So remember, I said we follow the Social Security's definition, which is a physical or mental impairment that lasts 12 months or longer or will result in death. So if I break my arm, I might be considered temporarily disabled, but I would not be eligible for a Community Fund trust because it would be unlikely that my broken arm is going to last more than 12 months or result in death. However, if I have autism, or if I get into a car accident and have a traumatic brain injury, or if I get diagnosed with schizophrenia, it's very likely that that could last more than 12 months. And so then I would be eligible for a Community Fund trust. I also want to mention that we are not a do-it-yourself type of organization. If you did want to work with Community Fund, we do still require you to work with your own attorney to make sure that you are getting independent legal advice. But we're always here to help support the person establishing the trust as well as their attorney. Let's see here. How do I make sure my boys are going to be okay after we are gone? This question breaks my heart because I can feel, what's going on behind this question. And I would say, from my perspective, as an attorney, as a parent, I think you need to look at many different aspects. And it's, of course, much easier said than done, right? You need to look at the financial side. Definitely people who have properly drafted trusts or other exempt resources like a stable account at their disposal are going to have more options than individuals who are solely relying on, the $700 or $800 they get a month from Social Security. So having some financial security and being set up during the parents or grandparents or siblings' lifetime is huge. That would include having good estate planning documents that you review every 3 to 5 years. Number two is understanding the residential plan. Are you going to be looking at the county DD board for assistance? Are you going to be expecting the trust to pay for a home? Are you expecting your child to be independent and able to pay for their own apartment or home with their Social Security or other income? You know, what are the residential needs? Regarding decision-making, guardianships or alternatives. When your child turns 18, do they need a guardian? And, you know, that's not the only time to evaluate it. Maybe at 18, they don't need a guardian, but in their 20s, their situation changes and they do need a guardian. Or maybe they needed a guardian at 18, but now that they're 27, maybe they don't need a guardian anymore. So considering it and reevaluating it every couple of years, I think is really important. If there's not a guardianship, is there a guardianship alternative? So when your child turns 18, if they don't need a guardianship, they could, like you, go and do estate planning. They could have a financial power of attorney to name someone to make their financial decisions if they're living but unable to handle their finances. They can have a healthcare power of attorney to name someone as their medical agent in the event that they're unable to make those medical decisions. There are mental health declarations. So if you have a loved one who has a mental health diagnosis and they go in and out of periods of competency or lucidity, whatever term you want to use, they can execute that document, naming someone else as the person who can make medical decisions if they're unable to because of a mental health concern. Make sure your own estate planning is in good order. And as I mentioned, review it, you know, at least every 3 to 5 years, or when there's a major life development. Someone turns 18, someone passes away, someone gets married, someone gets divorced, someone moves out of state. All those things should cause you to review your documents. And the last thing I would say is applying for benefits and or getting on wait lists. That is so vital. Many of the situations I see that have become emergencies are because parents, with all due respect, did not plan during their lifetime. And I know how hard it is. I know it is a lot easier to put it off or think you have more time. But a lot of the emergency situations I've seen over my career are because the parents did not plan. And then, you know, you've got adult protective services or, you know, the police involved, and people are living in homes on their own when they shouldn't be. And then, you know, maybe the DD board comes in, and then maybe there's a dramatic guardianship and the person's life is kind of completely changed. And sometimes it's for the better, and sometimes it's not. So definitely applying for benefits and getting on wait lists and getting on the waiver wait list if your loved one is eligible is really important. So setting them up for success. And then let's see here. It's 8:01, so I completely understand if people need to hop off, but I have one more question here, and then I want to make sure I turn it over to Wendy to see if there's any other questions. The question here is, if my daughter has high functioning autism, how will I know if I will need to be her legal guardian at 18? That is a very personal answer. If your 18-year-old is mentally unable to make legal decisions, medical decisions, financial decisions on their own, then guardianship is probably necessary. And I know that's really difficult sometimes to think about. Sometimes it's really obvious. Like I was telling Wendy, I have a family member who's nonverbal. who cannot independently go into a grocery store and could not go to a doctor and have a conversation about their health in any meaningful way. My family member needs a guardian, but maybe it's not as black and white in your situation. So maybe there's an option like having the financial power of attorney or having the healthcare power of attorney, where they can sign it and give you authority in the event they're unable to make those decisions at that time. The problem with those powers of attorney, though, is that they can be revoked. So I have seen that happen where someone has revoked their power of attorney because they get angry at their parent, or they want to run away with a romantic partner, and they take away that power. Guardianship is something you are taking from what they call the ward, which is the person who's under guardianship. Power of attorney is what the person is granting you. So there's kind of a take versus a grant. And I think it's ultimately based on the best interest of, in this case, your daughter, and whether she has the ability to manage those important life skills on her own. I will also say you can always revisit it. So if a guardianship is needed at 18, remember, you could always continue to talk with her doctor, and maybe the doctor agrees that a guardianship isn't needed in the future, and then it can be revoked. Wendy, may I turn it back over to you to see if there's any other questions?
Sure. Thank you, first of all, Amanda. This is a very complicated subject that you handled very candidly, very factually, and very understandably. It's good to know that there's tools out there to use for maximum dollar worth with minimal government involvement. You know, that's the greatest thing.
That's a great way of putting it, Wendy.
Okay, one family asked, with a trust, how would you handle inheritance of an asset, such as a house, equally to both a disabled and a non-disabled sibling with a trust?
Okay, so there's a couple of ways that can be handled. It could be titled 1/2 in the trust for the person with the disability, and then it could be handled, and then it could be 1/2 outright to the person who does not have a disability, the other sibling. It could be held completely in trust, and just knowing that 1/2 is for one sibling and 1/2 is meant for the other sibling. There's a couple of different options. I would be very cautious, though, just as from a practical standpoint, of naming co-owners in that situation, because they're still both 100% responsible if they're co-owners.
Okay. Another question. Would a power of attorney be okay instead of a guardianship? I think you touched on that. That one is can be X'd out, basically. The power of attorney can be contested at any time, and guardianship is not. It's pretty ironclad, right?
That's right. Certainly there are ways of kind of dissolving the guardianship. But yes, the power of attorney can be revoked or taken back at any point. That's both the good and bad of it. I will also say that even though I'm kind of making it sound like a choice, it's not really a choice. If someone is able to sign the document and able to communicate what their wishes are, then a power of attorney is the better choice, because the person doesn't need a guardianship. But if you're thinking a guardianship is needed, they might not, unfortunately, be competent. And I know a lot of people don't like that word, but it's the legal term. If they're not competent, then they can't sign the power of attorney. And I'll give a short, but I think very clear example. I actually did this with an older gentleman. He was only in his 70s. So he was not extremely elderly. I view now the 70s as quite young, but he was in his 70s. And when I was talking with him, I asked him who lived in his home, and I knew there was only one person, his son, who lived in the home, but he could not tell me who lived in the home with him. Even though we had other conversations about Cleveland baseball and all these other things, he could not tell me who lived in his home. He was not competent to sign a power of attorney, even though we had other lovely conversations. He needed a guardian in that situation. So it's not really an or, it's a which is the least restrictive thing. Power of attorney gives more autonomy to the individual with the disability, and that's typically most of our goals. But if a guardianship is needed, a power of attorney cannot be signed.
Gotcha. Will it pay for a credit card? Her daughter has one because she is not allowed a debit card and she should not carry cash.
Yes. So yes, whether it's a stable account or whether it's a trust, we definitely pay credit card bills. The only thing to keep in mind is what is that credit card being charged for? If the person is on SSI and they're charging their grocery store bill, the trust cannot pay for that grocery store bill part of the credit card.
Okay.
But if she goes to the movies and pays for the ticket with the credit card can definitely be paid by the trust.
Okay. And the last question is, I was told by my daughter's case manager that getting a guardianship for her as an adult is very difficult. Is this correct? She's 26. She is level 2 autism spectrum and has major issues with money.
Well, with all due respect to the case manager, I actually think it's the opposite. I actually think it's quite easy to get guardianship. It's an application that you find on the probate court's website. So if you're in Summit County, you'd go to Summit County Probate Court. If you're in Portage County, you go to Portage County Probate Court. You print off the forms, you fill them out. You need to get a statement of expert evaluation from a doctor that treats your daughter. On the form, it identifies who can fill out that document. So as long as you follow those instructions, you file it with the probate court, you pay a filing fee, which is probably the most painful part for some of it, for some of us. And then the court sets it for hearing 4 to 6 weeks later. A lot of probate courts are doing it by Zoom right now because of COVID. They'll send out typically an investigator to meet with your daughter, and the investigator will write a report. And if the investigator agrees, you'll have a brief hearing and you'll get a letter of guardianship 1 to 2 weeks later.
Great. Amanda, thank you again. To everybody who attended, thank you for giving us your valuable time. This PowerPoint and the entire presentation will be on our website at autismakron.org, probably by the end of next week. And I look forward to seeing some of you at the one-page profile and the guardianship and POA presentation next week. Again, thank you very much. Everybody have a wonderful evening.